love you, Linda. Love you.
The courthouse the other day in the hallway, you're singing "Oh Happy Day."
One word prayer. Justice, where are you?
Well, good morning. Welcome to Justice Served TV. Michael Bryant here. People were asking yesterday for Domino to make an appearance, and he was locked out. So today he's not. There he is. Say hello to everybody. Hi. How's it going? Yes. So today, hold on a second. Let me get rid of that. Today we have an early morning session in which the court is going to determine apparently how much of Aidan Kearney's cell phone texts, communications between he and Karen Read, oh yeah, this is the Karen Read case, need to be turned over to prosecutor Hank Brennan. This thing all began, and see you, Domino. Linda's coming along. She just had an audio issue. We're going to get her hooked up with a different microphone. Anyway, so the question became, on this phone, are there communications that somehow create for the prosecution an argument that there was consciousness of guilt in some sort of collaboration between Aidan Kearney and Karen Read at some point, I guess, after the death of Officer John O'Keefe. That's about all we know. I do have some of the documentation, and it's coming up at 10 o'clock. We just want to give you kind of a setup and a reset to talk about what this is all about, what may or may not happen. According to Aidan, and he was on with us a couple of days ago, he said there's nothing really responsive to this court order. And so he's fine. Just here, knock yourself out. Here's what's important to remember. And I went and pulled up the old search warrant to give a sense of, how long it's been since they've had this guy's phone, or I really should say phones, because take a look at what they got on this day. This was October 6th, 2023. These are all the phones. Let me see if I can make that a little more legible for everybody. See if I can grow it a little bit. Can I? Maybe I can't. Let's see. Anyway, they got 6 phones. They got 6 phones that day. And the question becomes, are we talking about one phone here? Are we talking about 6 phones? Look at that. iPhone, as well as a couple laptops and things. Anyway, so this was on the 6th of October. So now they're trying to suggest that somewhere on one or more of these phones are communications that suggest that he and Karen Read were colluding at some point, somehow, after the death of Officer John O'Keefe. I thought these were interesting because I hadn't looked at them in a while. Just to take a look at who was involved in some of this stuff. This is Lieutenant Jeffrey Perry, who did the inventory. Name doesn't ring a bell to me. Maybe it does to you. But this guy is really just kind of a clerk. I think he's inventorying things when they come in. But take a look at, let me get rid of this page and look at for you the second page. Linda, just give me a nod or a thumbs up when you're ready, and we'll bring you into the mix here. Okay. The second page. I believe, there we go. There you are. There's a thumbs up.
Out if I'm still buzzing. Am I buzzing?
Yes, you are buzzing.
Okay, I'm going to change my earpiece out. I'll be right back.
Okay.
All right.
Okay. And Tubi's also weighing in on the process. Okay, so that was page 1 of that inventory. Let's look at page 2, just because for no other reason than just it's interesting to see who's involved in this from the very early stages, right? Okay, let's see. Here we go. This is the first. This is the second page. Yeah, second page looks the same right at this point, except that it's got one more item at the top. Not worth worrying about. But on the bottom, let me get to the signature part of the bottom if I can here. There is that the right one? Am I on the right doc now? Let's see. These documents look virtually identical on my massive, well-organized set of documents here. Let me see if I can pull this up. It was a 2-pager. And the second page is has a name I don't know, you might recognize. Let me see if I can get this up here. Hold on. I seem to be getting the same doggone page. Well, I'm going to try one more time, and then I'll just spoil it for you and tell you who's on there. Again, this is the document from October 6th, 2023, basically a year and a half ago, when the phones, multiple phones, were seized from Aidan Kearney. And those are the subject of the hearing that we are heading for this morning. In about 10 minutes or so. We'll see how that goes. So, again, the guy who brought the documents or brought the material, inventoried them, big deal. But look who this is. Let's see if I can get this blown up just a touch. Okay, just a touch. Let's see who's involved in this mess. This is, if you can see it here, Brian Tully. I can see our little logos kind of over the cover. Brian Tully, and look at John Fanning, also involved. The inventory was made in the presence of John Fanning. Now, those are names we know, right? So these are folks that were involved, obviously, right from the very beginning. Are you back now?
Am I buzzing now?
It's not horrible. There is some buzzing going on.
Hold on a second.
Horrible.
I have one more
That's
thing.
horrible.
I have one more thing to do. I'll be back.
Okay. Anyway, so interesting that even a year and a half ago, when this thing was just getting underway for the materials we're now looking at this hearing, some of the names we know so well were involved at the time, and they're still involved. So that's what's happening. And to further fine tune what it is they're looking for, this is the order. I'm just going to read you some of this tidbits here. This is the order for March 20th. The hearing was March 20th, as you may recall, and they were very, very concerned about narrowly focusing what they were going to find or look for in these phones. And again, as Aidan has told us, man, there ain't nothing responsive. So he doesn't really care. He's not concerned. What I've always questioned and have been concerned about is, okay, when were the phones taken? We know October 6th, 2023. You're buzzing still.
Oh my goodness! It must be. This must have happened on Friday morning. I don't know what's going on here with it. If I take out my speaker, if I take out my microphone, am I buzzing?
Not at the moment.
Okay.
Not at this moment. So
buzzing back.
Now,
buzzing little
now
bee.
you're buzzing. When you lean back, you're buzzing. It's got to be something. You're very magnetic today or something. I'm not sure what it is. But
all right, I'll try it again. Hold the fort.
Stay right there. That's fine. Yeah, there's no buzzing. We can hear you.
I said I don't move.
Yeah, I can't suss that out from here, but yeah, you're definitely you got some buzzing going on.
I don't know what's going on this morning. Maybe it's my computer.
Yes, you're definitely buzzing. I think it's something because it's affected as you move around. So there's something going on with whatever
I'm
wearing or something. I don't know.
My
what
Apple Watch. I've been wearing that. Okay,
Yeah,
I'll take my Apple Watch off.
Yeah.
We're sussing this out. This
It's
is
now
live
buzzing
TV.
badly.
I moved my Apple Watch out of the way. Now
Everybody's chiming in on your buzz.
Oh my!
Your buzz. You're all a buzz. Say, don't move. Are you wired now? Can we hear you? No, that's it's got to be mic related or
computer.
Or IFB related.
Let's see how this works. If I take everything off and I just use my computer for now.
Okay, now you're let me see if I can unmute you because you're muted. Yeah, you've got yourself muted now. Let me finish this thought as you try to suss that out. Okay.
I am sussed out. I'm unplugged.
Now you're back. Okay. So anyway,
buzzing, everyone.
No, at this moment in time, not buzzing.
So I unplugged my earphones, my iPad, my IFB,
there's no buzz.
And I've unplugged my earphones. We'll have to go with what's on the computer.
Okay, it's actually lovely compared to the buzz. So what I've been doing is I went over the search warrant, which was from October 6, 2023, right? I went through that and just to show what was taken. 6 phones were taken from Aidan Kearney on that day. And obviously, it's either one or all of them that they're talking about. It's a little vague. I don't know if you recall whether they specifically mentioned a phone, but they had 6 of them at the time. And now I'm looking at the order that references when they are allowed to, what period of time they're allowed to cover. Okay. So it is any and all evidence of communications between the defendant and Mr. Kearney concerning 1, communications between Mr. Kearney and any witness or family member of a witness involved in the murder of John O'Keefe, to include but not limited to, and then the cast of characters we're familiar with: Matthew McCabe, Jennifer McCabe, Brian Albert, Chris Albert, Colin Albert, Juliana Albert, Michael Proctor, and Elizabeth Proctor from, here's the window, April 8, 2023 to October 5th, 2023. So that's a 6-month window. That is all that they are supposed to be looking at. Okay, so that's number one. That's most important, is the time period, right? Now, what are they looking for exactly? Pictures or videos depicting evidence of intimidation of a witness. Yeah, like you're going to be recording that. Hold on. Let me get my phone. I'm going to threaten to punch this guy in the face if he doesn't testify properly. Showing any intimidation of a witness or family member, and the rest is all pretty much cut and paste, referencing Officer John O'Keefe's death and then those same witnesses. And then number 3, data evidencing dissemination of data depicting evidence of intimidation of any of the witnesses. And again, the same cut and paste, same people, same period of time, October 8, 2023 to October 5, 2023. So that's what we're looking at here. And the big question I had, and I brought this up with Aidan because he had no clue either. We know when the phone was taken, right? We know from the inventory, Lieutenant Perry brought it in and Lieutenant Fanning helped with the inventory, right? We know that. And Brian Tully is the person who made the search. So all of that stuff's been established. But where's the phone or phones been in the a year and a half since they got them? When was any search done of the contents? Who had the phone during that entire period of time? Who did the search? And maybe more importantly for today, who's going to decide whether there's anything that is relevant and subject to this specific order? Okay,
Michael, can we do something off topic? Breaking news.
Oh, okay, sure. You want some real? Is this going to be real breaking news?
Real breaking news.
Okay, well, hold on just a second. I want to make sure we if it's real breaking news, we want to make sure it's properly.
We're told that an order just came down from Judge Beverly Cannoni that she has denied the Commonwealth's motion to redact the death certificate. The jury will hear that the medical examiner ruled that the manner of death is undetermined.
Wow, that's a defense win. How about that?
That's a defense win.
How about that? So occasional surprises coming from the bench of Judge Bev. So
promise you breaking news, and you've got it. Okay,
so that's interesting. I think it helps. It's a little nugget, but when you aren't, and we don't know yet. We know that Hank Brennan has suggested he won't be putting on the ME, right? Who filled that out, right? She's the one that filled out that death certificate,
right?
Right. So they're not putting her on. We think that's based on his representation, but she is on the prosecution witness list, so he could audibilize and call her at the last minute. Maybe somehow it helps him figure out that undetermined element that now the jury's going to see. I think that's a bad combo. She doesn't testify. Death certificate says undetermined.
Yeah, and as a matter of fact, when the defense gets to argue, the prosecution is trying to seek a way around their own state witnesses. They're trying to go around to get what the police wanted, what they decided 19 hours into the investigation without ever interviewing anybody. That's what they're trying to do. So they're trying to ignore anybody that came with a different viewpoint. Now, I know we had somebody on the chat earlier who was saying she's guilty, guilty, guilty. But the problem is the prosecution has to prove it beyond reasonable doubt in a court of law. And that's a fact that doesn't help them.
Yep, you're right. And to relate back to our conversation with Richard Gabriel yesterday, so important that this new jury understands that and doesn't get sidetracked by this whole, conspiracy theory. Well, yeah, the defense believes there has been a conspiracy. They don't have to prove a damn thing. So, if the jury starts going off down that road that, boy, the defense, they haven't proven any conspiracy to me. Well, they don't have to. And you just got to make that so clear to them from the moment they start selecting this jury.
Yeah, it was an interesting conversation. If all of you hadn't listened to last Gabriel, people have been retweeted because it was a fascinating conversation. And that point that he brought up, that the only thing that the defense has to be worried about is that Alan Jackson is actually prosecuting this case, right? He's not acting as a defense attorney. He's acting as a prosecutor. He's prosecuting the cops. He's prosecuting the system. He's prosecuting the investigation. But what he has to be careful for is that because he's taking on the burden of prosecuting somebody, that the jury thinks that the defense then has a burden of proof, and it shifts, that it gets burden shifted to the defense, and that's something he has to be careful for. Fabulous conversation. If you didn't listen to it, you really should. Yeah, and I think at 2-ish we're launching just kind of a chunk that we talked about, which had to do with his impressions of the now juror, the then juror, now attorney for the defense, because I think he had an interesting take on that, right? And so we cut that out, and that's going to
pop on it if you got less than an hour to watch the whole thing, which is worthwhile. But it's about an 8-9 minute chunk on that specific issue.
Right.
Hey, turn the fan on. Come on, let's go. Turn the fan on. That thing is going to be on soon enough because it's going to start to get hot in there for many reasons. So again, we're in Dedham. That's the Dedham courtroom ceiling. Notice they have, see that on the far left, that linear kind of looking box thing?
Yeah.
That's a air conditioner split, they call them.
I have, a matter of fact, if you look up.
Oh, there you go. It's a retrofit. It's a
retrofit. It's an air conditioner heater split. I have it right here in my studio.
Yeah. Is that a Mitsubishi? I can't tell.
That's a Mitsubishi. Yes.
There you go. Anyway, so those things, again, put that on the list of things I wish I had invented because they are so helpful and they're relatively inexpensive. So
right.
Anyway, so they've got that in the courtroom. They got the fan, they got the AC. All they are missing at the moment are the players, I guess. So what do you think is going to happen today? Is there going to be here's all the stuff you get to have, or is there going to be there's nothing responsive to this court order? What do you think?
No, I always worry that even if it's not what they say they're looking for, that they've actually looked through the phone and they're going to somehow wiggle their way around to something. They've had a whole thing that there's a colluding, a conspiracy. Well, Aidan, both as a journalist and as a person, he has a right to talk to the defense. He has a right to see what they're going to do. He has a right, if he wants, to participate, quite frankly, in having articles published to help her if he believes that he's innocent. That's not colluding.
I think it's free speech last time I checked.
Right. It's free speech at all. But this whole idea of they've made it, they're colluding with somebody. I mean, intimidation of a witness, we've seen it. Hold a gun to your head, or you go testify, or you don't testify, and your family will be safe. We've seen what intimidation of witnesses are.
Because common sense
is our.
You know it when you see it. You
want me to call security?
Oh, listen to that.
All right.
So do you want me to call security?
Let me know. Exactly. Thank you.
There was some chuckling going on, so I guess maybe it wasn't as serious as it sounded when somebody says, "You want me to call security?"
Right? That's the first thing we hear.
Okay. All right then.
Don't you love hot mics? I love hot mics.
I do. Yeah.
Don't laugh.
It's a party. Join the party, everybody.
Yeah. Maybe it was just a joke that was being made.
Well, you know how it is, Linda. When you're in these situations, you almost look for moments that lighten things up, right? Everybody takes it seriously, but I was big on just find a little nugget of humor somewhere to kind of loosen everybody up.
Yeah. Look at that. Disney became a YouTube member.
Hey,
congratulations, Diz.
How come she doesn't get a free membership? What's going on there? You don't even have a membership, do you?
I don't even have a membership. I think I better buy a membership for the channel.
Yeah. Okay. Well, we gotta work out some kinks. I think. So I would think some folks doing stuff for us should have a membership taken care of.
Who's this in front of Michael? Somebody's asking there's been so much confusion. Sisiski, Doolin, Canoni.
Yeah, it's a crapshoot. What's your best guess? You got 1 in 3 chances, I guess. Doolin, Sisiski, or Judge
Doolin's
Bell.
still on vacation, right?
I don't know.
And then it goes back to Sisiski, but I thought I had to go to Judge Canoni then to make the determination. So we're about to find out, aren't we?
It's Judge Roulette.
Judge Roulette. Oh,
is this I couldn't tell from the fan. Is this her courtroom? It looked a little different on that pullback.
It looks a little different. Excuse me.
Yeah, this looks like the courtroom, the big courtroom.
Is this the big courtroom?
Or it might be the medium-sized courtroom where the last hearing that I went to was held, and that was where they had the new witness intimidation charge.
Yeah. Thank you, Happy Annie. Happy new member.
Welcome to Zoom for Government. Enter your meeting ID followed by pound.
Yeah, so that's the clerk is Jimmy, right?
And by the way, Chris, I couldn't find you. I found the other.
Yeah, it sounds like someone said it sounds like an. I thought I had to go then to her.
Participant ID followed by pound. Otherwise, just press
Once the
pound
50
to
rule that they
continue.
get access, then I had to go to go
You
back.
Hey,
are
Juana says it's Bev's courtroom, but if it is, it's a weird camera angle. It's not the normal camera angle.
You have been added to the waiting room.
It looks like it has more
Cannot talk
depth.
or listen until the host admits you to the meeting.
That's what it's come to, guessing what courtroom it is. That's where we are with this case.
That was Jim the clerk, someone's saying, yeah.
Yeah, I mean, I don't know. I don't know Jimmy that well.
You are muted.
It's a crazy system here that's going on with this phone.
But you're not buzzing, so that's a plus.
Well, obviously, after we finish, we're going to have to suss this out by
Yes.
Now
we'll get to, let me call the IT department.
I have both my New York stuff with me, and I have the
You are
stuff.
unmuted.
We'll get the head of our IT department on that.
Can you hear me?
I can hear you.
Yes.
Josie Miller said she's just joining. So this is the hearing to determine what, if anything, is going to be turned over from Aidan Kearney's phone to Prosecutor Hank Brennan from the related matter in which Special Prosecutor Cosgrove sought an order to obtain that information. And now he's basically been a tool. He's a tool, and I mean that in the nicest way. He's a tool for Hank Brennan to get stuff from Aidan Kearney's phone, give it to the prosecutor Hank Brennan, and use that against Baron Reed.
And my dog Tubi is complaining.
Tubi is incensed about this.
Yeah, he's incensed. He's the defense dog.
He's
my avatar when we go off. I put an avatar in when I'm listening so that you don't get distracted because he's been brought up well by his mom.
Oh, you still have the Tubi avatar?
The Tubi avatar, yes, I still do. Good morning, everybody. By the way, good morning, everybody who's here.
Yes, thanks for joining. This could be very interesting, or it could be very boring, but you never know with this case, and that's why we're here. It's very important, that's for sure, just in terms of the reach of the prosecution to get information they believe is appropriate, and it's already been sanctioned to some degree by a court order. So this is really the defining moment. You can have court orders for all kinds of stuff, but if there's a search and nothing has been found that's responsive to the court order, then you're done. Oh,
that's interesting. Who just said? Amelia Walsh just said her dogs are going crazy because of the beeping, and that Tubi could be hearing the beeping.
Oh, okay.
I have a studio here, but I don't have the door closed to the studio.
Interesting. Okay.
So do we see any of the participants, or is everybody by Zoom?
Yeah, that's a good question. I can't tell, again, from that camera angle, if they're even tilted down far enough that you'd see heads.
Yeah.
So anyway, so the plan, the goal here of the prosecution, of course, is to find something incriminating on those phones so they can at least make the argument that there was some weird collusion between a reporter and his subject that rises to the level of consciousness of guilt, that she felt so guilty about having killed Officer John O'Keefe that she conspired with Aidan Kearney to put stories out there or to create this don't look at me illusion, look the other way.
How is that intimidation? How is that intimidation of witnesses? That's developing a plan, a theory to make sure that if you think you're innocent, you're innocent. You don't get convicted, wrongfully convicted, like, all the wrongful convictions we read about every single day in this country.
Yep, it is a twisted story, just this element.
Yeah. So it looks like people must be appearing on Zoom. I mean,
yeah, a lot of folks checked in, that's for sure.
There's a lot of check-ins going on right now. Yeah. Do we see Mr. Cosgrove? Is it supposed to be Mr. Cosgrove? And is Mr. Brennan going to be there? I mean, Cosgrove, it's interesting because the first time I saw him was before Judge Doolin, and that's when he was like on a couple of accounts. He was saying, yeah, I know, I think they're kind of close, blah, blah, blah. Okay. But then we had the second hearing where, all of a sudden he wanted to revoke Aidan's bail.
You are unmuted.
There's the top of somebody's head. Somebody says Unetti and Elizabeth or Liza is there somewhere. Well,
It's
the
on
note says on the screen,
Yeah.
but I can't see it.
You are muted.
Oh, now they're
You
letting.
are unmuted.
Oh, now they're unmuted. You're seeing this sausage being made.
You are muted.
And it's not always a pretty sight.
Yeah. There you go. So they're all seem to be on Zoom, except maybe I'd imagine that Cosgrove would be
I would think
there.
that Yannetti would be there. I mean, they're the local folk.
Yeah, but he's well. I guess the main thing is now who's going to take the main lead? Will it be Aidan's attorney or will it be Mr. Yannetti for Karen Read?
Yeah, that's a very good question because they've blended these two. I couldn't tell you. I don't know how they're handling it.
Someone says that we have ads on during the live. We have no control over the ads. By the way, just so you know.
Yeah.
They're going to change that. YouTube is going to change that.
Something's happening in May. We're not sure what it is, what it means. You know, we just kind of handle the content.
Yeah. So please drop your blinders blocking the bottom of the screen. That's
well, I'm see and I don't know. Let me see if there's a way to do that.
Yeah. That's why we can't see the screen.
You would think I would know that. Let's see if I can find a way to do that.
You and I talked about getting rid of that bottom banner.
I know we just never got around to it. Let me see if I can find that template.
No, Disney says we can't do it right now, but that's
we can't do it now. We have to wait. Okay.
I think that we will get rid of that bottom banner that we've been talking about it.
Yeah, it gets in the way of graphics too.
So, but they're still dialing.
Welcome to Zoom for Government. Enter your meeting ID followed by pound.
Beep, boop, boop, beep, boop, boop, boop.
All right, somebody tells me the banner's not blocking anything because it's black everywhere.
Yeah, I see his or her head. See that?
ID followed by pound.
So the line above our graphic is really where the video ends.
It's really interesting what's going to happen and who's okay. Aidan Kearney
added to the waiting room.
I don't know.
You cannot talk or listen until the host admits you to the meeting.
So she hasn't started.
Is that your music?
Not mine.
No.
Someone said we do have control over the ads. Busy. I thought we had.
Hey, let's see what we've had so much breaking news while we're killing time here. While we're in the business, we're kicking rocks. Last night, what happened? Remember the big appeal, double jeopardy, jurors supposedly unanimous on counts 1 and 3. That whole thing.
You are muted.
There was a secondary appeal.
Pressing
just on the 26th, 2 days ago, the reply brief was filed by the defense, who are filing the appeal, of course, suggesting double jeopardy attaches and there should not be a second trial. The next day, which was now yesterday, the Court of Appeal denied that appeal. So, in an effort, what appears to me to be an effort to kind of clean things up before the start of trial number 2, the appellate issue's over.
Is everyone here? Hold on, Michael.
Yes.
Well, that's it. Now we're muted.
Jim, just so you know, we hear a big echo. I think 2 people might be in the same room, and that might be causing it.
Maybe it's your buzz.
Does he say we don't have? That's just what I thought. We don't have control over when the ads play on our subscriber. We do not have control. They're changing that though to avoid mid-roll ads in May because everyone's complaining, including us.
So anyway, that's it. Oops, where'd they go? That's an issue that's no longer of concern. So they've gotten that out of the way.
And this morning, breaking news: Judge Beverly Cannoni denied the Commonwealth's motion to redact the manner of death as undetermined from the death certificate. So the jury will hear that exculpatory piece of evidence as the defense has put it forward.
That's interesting. And even though they won't hear it, perhaps from the ME, unless now the defense decides to call her, even if the prosecution doesn't.
Right. And I'm sure they will.
Now they can say, here it is. Didn't you prepare this document? I hope they have a cleaner version than the one we've been able to find.
Well, yeah, I mean, somebody had taken a photograph of, I guess, probably on the screen or something, and that's
Yeah, it was bad.
right. Yeah.
You are unmuted.
You know,
We still have the echo?
see, they're having problems there. They're having problems with echo. We had problems with
You
buzzing.
have an echo?
It's a
We have
bad
problems.
tech day.
We have echo problems.
Okay. All right, I'm all set.
Oh, okay.
This is the translation of all set.
Hey, Paul, I'm all set.
Looks like they are all set finally.
Folks, make sure your cell phones are off and put away for me, please. Thank you.
Kathy R is getting impatient. As Tom Brady would say, LFG.
Yeah.
Oh, calm down. It's going to happen.
Here we go. Now they're putting the cameras moving down so we can see
Okay.
the screen. And then we will probably have the appearances being entered.
So that's Sisiski, right? No. Is it?
And 23313, the Commonwealth versus Karen Reed, and secondly, the Commonwealth versus Aidan Kearney. Can I have the parties identify themselves?
Mr. Clerk, hold on just a moment, please.
Sure.
I need to plug in because I believe we have parties on Zoom.
Okay, I'm sorry.
It's also my understanding that we're only here on case 0117.
That was also my understanding.
Okay.
Thank you.
And do you have the Zoom identification link for me, please?
I do. It's right here.
Thank you.
There's no passcode.
Thank you.
Remember, there's two docket numbers that are attached to this. 00117 is the one that Aidan Kearney filed a intervener motion to quash the subpoena.
Yeah. 117 is Karen Reed. There's a Mr. Brennan.
So that answered our question. And I said we thought Mr. Brennan had to be here because it involves the Karen Reed docket number. Even though there's two docket numbers, this is the Karen Reed docket number.
Yeah.
Okay, Mr. Clerk.
Here
we go.
Judge off the
Thank
case
you.
and identify the parties.
22117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves, starting with the Commonwealth?
Good morning, Your Honor. Hank Brennan for the Commonwealth, relative to docket 00117.
Good morning, Attorney Brennan.
Good morning, Your Honor. I'm Robert Cosgrove. I'm a special prosecutor on the Aidan Kearney cases, and I suppose for purposes of this motion, I'm the respondent to the Rule 17 motion.
Good morning, Attorney Cosgrove.
Good morning.
Hello, Your Honor. Timothy Bradel for Aidan Kearney. I see him on the Zoom for the record.
Good morning, Attorney Bradel. Good morning, Mr. Kearney.
And Mark Federer for Mr. Kearney. Good morning, Your Honor.
Good morning, Attorney Federer.
And good morning, Judge. Attorney David Yannetti for Karen Reed, who is also present on the Zoom.
Good morning, Attorney Yannetti. Good morning, Ms. Reed.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Attorney Little. Anyone else here that we need to recognize before we proceed? Doesn't seem so. Okay. Folks, we are here on two related matters this morning. As an initial matter, we are here because there seems to be some confusion concerning my order of March 20th on docket 615 on the Commonwealth's Rule 17 motion. Also, we're here because there has been a motion for protective order, docket 636, filed by intervener Kearney, and so we will hear that as well. So with regard to my order, let me start by saying this. Going back to Attorney Brennan's affidavit filed in this case on March 5th, 2025, in support of the Commonwealth's motion for records, Attorney Brennan, you specifically stated that quote, "It's been represented to the court by defense counsel Bradel on behalf of Mr. Kearney that there's an implicit long-term mutual assistance and mutual defense agreement between counsel for Mr. Kearney and counsels for this defendant, Read. On the basis of that sworn statement, I specifically inquired of you, Mr. Brennan, at the hearing on this matter last week, do any of the 3 categories of documents and data that the Commonwealth seeks by the Rule 17 motion include communications with Mr. Kearney and counsel for the defendant in this case? You replied, no, these would be privileged. So based on these representations and the court's belief that there were no privileged materials implicated by the Commonwealth's motion, I ordered that all communications between Mr. Kearney and Ms. Read during the time frame in question with regard to these 3 articulated categories be produced. However, subsequently, the special prosecutor in Mr. Kearney's case, in possession of the documents in question on March 26, informed the court that 1, there are in fact a substantial number of communications within the documents and data requested that are indeed communications between Mr. Kearney and Ms. Read's counsel. And moreover, the special assistant district attorney in that case took the position, contrary to the one asserted by Attorney Brennan in this case, claiming that those communications are not, in fact, privileged. So my order did not specifically exclude from production communications between Mr. Kearney and Ms. Read's counsel because the court was told there were no such communications, and in any event, the Commonwealth acknowledged that they were privileged. So my first question is to you, Attorney Brennan. Respectfully, did I misunderstand you, or perhaps vice versa? In other words, I understood that you weren't requesting the production of any privileged communications, to wit, communications between Mr. Kearney and Ms. Read's counsel. And as such, if that is the case, and we did understand each other, I can simply clarify my order for Special ADA Cosgrove that those claimed to be privileged communications will be excluded from the Rule 17 production, and we can move on. If that's not the case, I'd like to hear why.
Sure. He's not happy.
Yes, you may.
Happy.
Well, you know, Judge.
I think there are 2 separate issues regarding privilege. One is whether Mr. Kearney's attorneys, Mr. Betterow and Mr. Brado, have privileged communications, and separately, Ms. Read's attorneys' communications with Mr. Kearney. When Your Honor asked the question, I believe we were referring to Mr. Kearney's attorney. And so what I understood from the motion filings is that there were no privileged communications between Mr. Kearney and his attorney in those phones. And so there would be nothing privileged to protect.
Okay, I specifically asked, does this include communications between Mr. Kearney and counsel for the defendant, Read?
I don't doubt that you asked that if that is what happened, but that wasn't my answer to the question because perhaps I was focused more on Mr. Kearney.
So you confirmed today that we misunderstood each other?
Or I misunderstood. I'll take responsibility for it. But I was trying to be protective of the attorney-client privilege between Mr. Kearney and his attorneys, Mr. Brado and Mr. Betterow.
Okay, well, we all agreed, counsel, that those in fact would be privileged communications without question.
Of course.
So let's turn to, if you would, the second issue, which is one that you raised in your affidavit. You specifically raised that question in your affidavit, docket 547.
Undoubtedly. I do not believe there is any attorney-client privilege between Ms. Read's lawyers and Mr. Kearney, because those communications are not covered by attorney-client privilege because none of Ms. Read's lawyers are attorneys for Mr. Kearney. I pointed out that in an earlier hearing, and I have the transcript of it, it was December 17, 2024, when there was litigation in Mr. Kearney's case, docket 0313, that there was a position taken by Attorney Bradel. And he began by telling Judge Krupp, well, there's a joint defense issue, Your Honor. And Judge Krupp asked, so it would predate any jeopardy to Mr. Kearney. And then Mr. Bradel responded, well, it's a little more complicated because we know he was under investigation along with Ms. Read without any resultant charges, so we would contend that does not fall under the umbrella. After more questions by the court, Mr. Bradel answered, we don't have an agreement, but there's been an ongoing long-term implicit mutual assistance and mutual defense that I myself have been part of for a long time, and Attorney Bedrow has as well. And Judge Krupp said, I really have no idea what that is. And so inevitably, there was no establishment of an attorney-client relationship between the two. Inevitably, and after that, Attorney Bedrow attempted to file an appearance on behalf of Reed. And in that, there was a supplemental motion, and it's docket 549 and on 0117.
And docket 549 contains Attorney Yannetti's sworn statement that there was no joint defense privilege between Ms. Reed and Mr. Kearney.
Exactly. And so I think I had the assumption there was no attorney-client privilege. If I misspoke, it confused the court. My apologies, but inevitably, there is no attorney-client privilege that I understand.
Well, he's said he may have misspoken now 3 times.
I do not know what is in the bills. I have not asked. I don't want to know unless it's put to a court order. But based on the affidavit of the search warrant, and based on the pleadings in this case and the court on the last date, but those pleadings, which were filed publicly by the Commonwealth, and it's docket number 53 relative to docket number 53 relative to Mr.
Did they just freeze? Yeah,
they're frozen up.
Pleading, it is set out by the Commonwealth pleading that there is in fact information demonstrating that the Reed team provided Mr. Kearney with information, documents, videos. It suggested that at times they would suggest angles for him to use it or to refrain from using it. And it provides a number of examples, including an example on 8823, when they're asking for information, Mr. Kearney, so one of the attorneys.
Attorney Brennan, I'm going to ask you to pause right there because I think we've reached a point where I have a threshold issue that may require either a Bishop Franklin protocol or some inquiry into the nature of the privilege that may or may not be asserted by Attorney Bradel. And so I think it's appropriate at this time, Attorney Bradel, that I turn to you, not with regard to the protective order, but with regard to the issue of whether your client claims a joint defense agreement and related privilege to communications between himself and attorneys for Ms. Reed, such that I need to limit the scope of my order of March 20th.
Judge, thank you. We do not assert such a privilege. I said in a much different context a long time ago that we had been sharing information and talking to each other and helping each other. And I said that there was an issue. I didn't say there was a privilege.
Okay.
So we are not asserting that. There is no formal agreement. There's no formal privilege. I said it was an issue to be looked at the time. That's all I said, Your Honor. And in terms of this, Your Honor's order, I don't even know why we're talking about this, Your Honor. The ostensible purpose of the Commonwealth's request was to attempt to show consciousness of guilt on the part of Ms. Reed. So why would communications to other parties besides Ms. Reed have any relevance? And in fact, in your order, you just say that the only communications that are on the table here, so to speak, are communications between Mr. Kearney and Ms. Reed.
I'll stop you right there, Attorney Bradel, because you raised an excellent point, and that point being is that point from the court's perspective is in an age of group texts and other means of communications with multiple recipients at the same time, we certainly have the likelihood of communications between your client and Ms. Reed that may also include members of her defense team. So it is my belief that is what might be at issue, but I will probe further of 88 Cosgrove on that point.
I mean, if you ask me, Your Honor, the pleading, that the impounded pleading filed by Mr. Cosgrove is completely immaterial. The whole reason for this is consciousness of guilt. So there are we're privy to these extractions. There's absolutely nothing in them that is covered by Your Honor's order. There's no communications between Mr. Kearney and Ms. Reed regarding witness intimidation. There are none. So there should be exactly zero documents or texts or emails that should be responsive here. Absolutely zero. And I don't have the thumb drive that Mr. Cosgrove gave to the court ex parte. So I can only imagine what's in that. And we are anticipating a request that you will look at that, to ask you to look at that in camera and see if that complies with your order. It doesn't. It cannot comply with the order. Your order said Kearney and Reed, not third parties that may or may not have spoken to Reed. And these are things that are privileged among that team. So this is a can of worms that the court did not open by any stretch. And I think that, Mr. Cosgrove's role here is completely ministerial, Your Honor. And the fact that he's trying to jump outside of your order is incredibly inappropriate, in particular because these two prosecutors are in different positions due to a conflict of interest, an express conflict of interest that has been identified and supposedly acted on by District Attorney Michael Morrissey. So their communications need to be limited because there is a conflict. Your Honor limited those communications very appropriately to potential evidence that those two defendants could have communicated in terms of some criminal acts. And we're telling you there's nothing there. We don't expect you to rely on our interpretation, but there is nothing there relative to your order.
Thank you.
So the fact that
Attorney Breda, I'm gonna ask you to pause for a moment, and I'm gonna hear from Special Assistant District Attorney Cosgrove, specifically with regard to this issue. In your communication to the court, you suggested that in your judgment, the production would sweep in a substantial number of communications between Mr. Kearney and Ms. Reed's attorneys. How would those be swept in when the order specifically calls for communications between Mr. Kearney and Ms. Reed?
I think the actions of Ms. Reed's attorneys on her behalf are the actions of Ms. Reed. And if one reads the sweep of the communications between Mr. Yannetti and Mr. Kearney, and between Mr. Jackson and Mr. Kearney, and Ms. Reed and Mr. Kearney, one sees a pattern of feeding information to Mr. Kearney. I think that they act together in that respect, Your Honor.
This is really interesting. Cosgrove is now taking a position like he's Brennan, right? Like he's prosecuting the main case.
That position, the court's position is that the order spoke very specifically and very clearly to limit the Rule 17 motion to the production of only communications between Defendant Reed and Kearney and Defendant Kearney concerning those three areas of inquiry. So I am specifically requesting and ordering the Commonwealth in that case to review the documents called as a result of the Rule 17 motion in my subsequent order, such that the production will only include communications between Kearney and Reed.
Well, I will, of course, comply with Your Honor's order.
Thank you. Folks, I think we've covered that point, and I
Oh.
don't think I need to hear any further on this. The order is clear on its face, and I expect the parties to comply with it. I'd like to turn now to the issue of the motion for protective order from Mr. Breda.
And that was filed just yesterday, late yesterday.
So
but this
I'll
was a
hear you on
Smackdown.
this,
The judge understood what
understanding
they
that I
were
have had the
really
opportunity to review the attachments and certainly the basis for this. But I'm not, I'll preview where I end up, Attorney Bradel. I'm not quite clear on the scope of your request as contained in your draft order. As an initial matter, I'm only issuing an order in the Read case. This is not a hearing on the Kearney case. I appreciate that you have a congruent request to the court in the Kearney case, and that it may make sense that whatever the court does in that case should follow what the court does in this case. That would seem to make sense. But I'm only hearing the motion as it regards to this case. Your request, I'll note, asks that the court order all prosecutors and police in the above captioned case to maintain the confidentiality of the cell phone data and any other investigative information and or discovery in each case. So I'm not prepared to discuss the entirety of investigative information and all discovery in this case. I am tasked with only addressing Mr. Kearney's specific cell phone data that is the subject of my order of March 20th. But you've specifically requested that the court order that police and prosecutors are ordered to refrain from sharing such information with particular parties identified in Mr. Kearney's affidavit, and any other parties not part of the retained prosecution teams of Ms. Read or Mr. Kearney. Aren't they already under a duty not to share such information with anyone outside the bounds of what you request?
They are, Your Honor. Judge Kearney specifically found a substantial risk existed that any further communications about the evidence or the witnesses would jeopardize a fair trial. And she made that specific finding, and she imposed, I believe it's a 4-part gag order on the Read attorneys. Nonetheless, as shown in my exhibits, Judge, these outside people are receiving information that in no way would a prosecution team ever share outside of anything ethically share anyway, any such information. And there's 3 examples of people who are, out there saying we've gotten this, we've gotten that. And we strongly believe that they are doing so. Just to avoid the slight awkwardness, Judge, of me arguing something that benefits Ms. Read, I would invite, just for the record, the Read counsel to join me in this motion, Judge, because of the leaks that are going on, just as a threshold matter, if I may do so, Your Honor.
Are you merely asking me to add a belt to Judge Kearney's suspenders?
I think so, Judge, because we need one, and we need one as to the specific information. These 3 people have repeatedly stated that they're privy to inside information, and with respect to Mr. Kearney's information, but although we strongly contend there's nothing in there that is responsive to Your Honor's order, nothing. To the extent that there's anything that's shared between these 2 different prosecutors that are on separate islands due to a stated conflict of interest, we want to specifically ensure that as to the discovery that Your Honor's focused on here, that these orders are in place, that there's a specific order. It's sort of another step from Judge Kearney. She said that, well, the general rules of ethics aren't working here, so I'm making a specific finding. I'm giving you a gag order. Well, guess what? Judge Kearney's order didn't work either, based on my exhibits A, B, C. And so we're asking for another step to just really put a fine point on it, that these 3 people must stay away. And a general order as well as part 2 is my part 2. And to the extent that those people have any sort of further expressions of leaks in the media or on the internet, I think that ought to be grounds for a live hearing with sworn testimony about these leaks.
Understood. Okay.
So that's why I'm asking, Judge. Thank you.
Thank you, Attorney Bradel. Attorney Little, Attorney Yannetti, do you have anything to add on this point?
We don't. I mean, I think that we generally take no position here. It is concerning to me that Special Assistant District Attorney Cosgrove revealed in a publicly filed motion communications with, or I should say between Mr. Kearney and counsel for the Read team when the court's order was specific. My understanding is that he omitted some statements of caution and admonitions that we may have given to Mr. Kearney about the nature of demonstrations, etc. So it seems as though he cherry-picked statements in an effort to make us look bad when it was outside the court's order. It was unnecessary.
Attorney Yannetti, are you speaking to something that Attorney Cosgrove has purportedly done in this proceeding in the 117 matter?
No, I believe it's a motion that he filed in his prosecution. Again, detailed, that material.
Thank you. Okay. Okay, folks, I will take that matter, the motion for protective order, under advisement, and will endeavor to respond to you as soon as practicable on my decision on that. In the interim, ADA Cosgrove, Special ADA Cosgrove, I'd ask you, how soon do you believe the Commonwealth can reproduce the records in question per my order that are called for by the Rule 17 motion?
Well, I would say we can probably extract from the thumb drive the conversations with Mr. Yannetti and Mr. Jackson. I may be able to get it done today. I think Monday would probably be a realistic filing date.
Thank you. We'll expect something by close of business Monday, and if you encounter any difficulty or challenges in doing that, just please let the court know, and we'll make whatever accommodations we need to make. Okay, folks.
Your Honor, is that thumb drive going to get returned to the Commonwealth?
Yes, it will.
All right, thank you.
And it has not been viewed, it has not been released, and it is being held under seal and impounded at the moment, and it will be returned to the Commonwealth promptly.
Thank you very much, Your Honor.
Attorney Brennan.
Your Honor, just for clarity of the record, I'll be brief. There has been no conversations between Special Prosecutor Cosgrove and I about contents of any of these items. In fact, even though I do not think I had to, that's why I filed the Rule 17, so there is a clear public record that we're beyond reproach. Secondly, the pleadings I referred to were pleadings that were filed in Mr. Kearney's case publicly before this issue even came up. So it is not divulging information to disseminate to the public. And finally, just so it's crystal clear, I filed a motion for a gag order in Ms. Reed's case because there was significant evidence of distributing protected materials, and that order was allowed at my request. There is no witness or person, as far as I know, in the Reed case that has disseminated any information improperly. I would not allow it or tolerate it if it happened. So I want that to be crystal clear based on the representations we just heard.
Understood. Thank you, Attorney Brennan. Thank you, Attorney Cosgrove. Thank you, counsel. No, we are adjourning the hearing now. Thank you.
Is the best in the world.
Thank you.
Thank you, Your Honor.
That was me going a little crazy that this judge is taking no BS.
Goodbye.
Yeah. Goodbye. Okay, so let's get into what we heard and what we didn't hear. Only at the very end did I hear anything from the judge suggesting that this material has been properly watched over, protected. He says it is sealed. And what we're talking about is they've already extracted what they need, and it's now in written form somewhere on a thumb drive, right? That's what it is. Not like this phone is just floating around. The material's been pulled from it, and it's now on a thumb drive to be produced under the court order, which has now been tweaked a little bit, and apparently Special Prosecutor Cosgrove is going to do the tweaking. Gives us some sense for the first time of who the gatekeeper is. I guess it's Cosgrove.
Yeah, that doesn't warm the cockles of my heart, because I want to talk about this protective order. Because you're right, you had those questions, right off the bat.
Of course, that was the most important thing, and the judge's concern, valid, was, look, I exempted anything that involved attorney-client privilege from my original order, and now it looks like you're trying to weasel a little bit and get some material between what would have been Aidan Kearney and Karen Reed's attorneys. even though they don't have, as it was made very clear by Yannetti, they do not have a mutual defense agreement between counsel, right? But my question is, so what? That's one way to create the attorney-client privilege. You can also create it as a matter of fact, the way the facts lay out. If I go to Karen Read's attorneys and I talk to them about a matter that has impact on her case, there may be the creation of an attorney-client privilege from that communication, from that contact. It doesn't have to be expressly agreed to between the parties, but the contact itself creates some question about whether a privilege exists. You don't have to say, excuse me, before I ask you this question, will the attorney-client privilege attach here? That's not the way it works. It can happen as a matter of the course of conduct between the parties. So I'm not so sure whether there is or isn't one. And I think that's why the court was so concerned and why the court said, first, is there a mutual defense agreement? No. I'm still not comfortable with any communications other than Aidan Kearney to Karen Read. That's what we need, Mr. Cosgrove.
Actually, I thought it was even more severe than that. Okay, Michael. When I was listening to him, first of all, I love this judge. I loved it. I wasn't sure about the other day, but today.
No, he was a little clunky the other day, but he seemed to be more focused.
And he's focused on. And the problem is, you have all these case numbers. Okay, so he's only dealing with the 117. He's basically said, he stopped Hank Brennan and also Cosgrove in the tracks. He said, look, I ordered one thing. And it sounds like you're doing more than one thing, okay? I ordered only this, the communications between Aidan Kearney and Karen Read. That's it. That's all I ordered. And now it appears that you may be thinking of sharing, is what he basically was saying, all sorts of different things with the attorneys, right? In group text, if there were chats with group text. And then we heard that even what Cosgrove had quote, put in a public filing, which is how you publicly leak something when you shouldn't be doing it.
Right.
Attorneys, conversations of the attorneys, but cherry picking what was picked. And it sounds like Cosgrove is the prosecutor in the Karen Read number. And that's what Hank Brennan got up and said, no. I didn't ask for any. I didn't ask for any of this. I didn't ask for any of this. The judge says, well, I'm making it clear. All right. I only want my order complied with. My order was this. I don't know how many times he said that. My order was this. Okay. It wasn't anything else. And he said, I understand in this day and age of group text, but that's not what my order was. And that's not what we're dealing with. You have to comply with my order. And he told both of them that. And I thought, I thought it was very clear to me that there may be an implicit agreement, even though Brennan denied an actual agreement, that, wink, 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 wink.
Oh, between the prosecutors, there's not a doubt that they are in concert. There's not a doubt.
No doubt in my mind, even though Hank Brennan got up and said, no, I didn't ask him to do this. This was an implicit in concert. And I just tweeted on our behalf. I know there was a little bit of a mistake because I said I have to tweet it out right away. This was a big smackdown. This was a huge smackdown to the Commonwealth. This is something that I wish Judge Cannoni would do at some time, right?
Have you ever heard her interrupt the Commonwealth during an argument or a statement? No, never.
No.
This guy, Judge S, doesn't seem to have that favor for the prosecution.
No, and then he led Bradel, and he said, I'm going to review my order again. The document is that you're providing is this. You're not providing anything else. So,
It's so simple. Yeah. And again, the order referenced very specific people, not just between Aidan Kearney and Karen Read, but relating to very specific people, all the usual suspects that we're aware of, the Higgins, the McCabe's, all of those folks. So it's even further refined than just between those two.
Right.
What the court was most concerned about was keeping the attorney communications out of it, because it is a very murky relationship between these two parties, Aidan Kearney and Karen Read, and their respective attorney teams.
Well, I'd say where there is a murky relationship is between special prosecutor and special prosecutor.
Of course not. Of course.
And as was pointed out, I think it was Bradel Yannetti pointed out, the reason why there's special prosecutors, this is a conflict here. They're supposed to be independent. And it appears from their actions that they may not be independent. And Brennan was like, no, that's why I filed the rules. I filed this. I did all this to make sure I didn't violate anything. But you know what? It's clear to me, and I think it was very clear to this judge, that they were trying to get around his order by reading it and then saying, and Hank Brennan, I can't, how many times did he say, I may have misunderstood?
Yeah. Well, he doesn't know the word lie unless he's attacking somebody else.
Yeah. And the judge said, did we misunderstand each other? So the judge was like, gave them an out, but
of course,
but you know what you miss if you just read a transcript, you miss the tone of voice, because the judge wasn't like, oh, did we misunderstand each other? He was like, did we misunderstand each other? Right, Michael?
Yep. Oh yeah, it was clear that he was helping him with one hand, but smacking him down with the other. Yeah. And Brennan, he always looks shifty, but he really looked shifty today.
Today he really looked shifty, but he also looked he looked a little bit like
a little mousy, a little.
Let me go back. Let me go into the shell here.
I'm here to tell the court.
At the end, he got back some of his Brennanism. He got back a little cocky about what was suggested and what may or may not have been leaked through a document.
He tried to blame the defense again. Oh, the reason why Cosgrove had to do this is because of all the leaks of the defense. He tried to blame the defense again. There we are. I mean, let's get the transcript of it. This was unbelievable. And then they went to the Aidan Kearney's motion for protective order regarding the sharing of the cell phone document, but it only applies in the 117 case. So the judge asked on the thing that Mr. Cosgrove leaked officially in motion papers, what case was that on? And it turns out it was on the case Cosgrove was prosecuting. So I think implicit in what the judge is now telling Aidan Kearney is that file this protective order everywhere. File it in that case, file it as an intervener in the Karen Reed's case, and you could file it here. He's taking it under advisement, but he's granting it. But no doubt in my mind, he's going to grant that protective order.
Again, I'm back to my original question, which is, who's really the gatekeeper? Is Cosgrove the guy? It's going to go directly from Cosgrove to Brennan? Nobody in between is going to say, well, whoa, wait a minute. What about this, and this that violates the turnover order?
Yeah, that's what it feels like. But the judge's limitations of, I only want these two things.
Okay? No, I understand the limitations. I'm concerned about the messenger.
Oh yeah, Cosgrove is the special prosecutor, is the one who gets to go through it.
That's ridiculous. And I'm actually surprised that Bradel and even Yannetti, who didn't want to join, he didn't want to join in the protective order. He said, we have no position here. Right. But either of them could have said, Judge, we're not comfortable with the way this is set up in terms of reviewing and dispensing this information, especially considering all the confusion that seems to be going on. And what were the problems with Mr. Brennan? He misheard, or he misspoke. He misspoke. Yeah. So we want a third party here, whether it's the court looking at it in camera or some other, pseudo taint team. We don't want it just going from Cosgrove to Brennan.
Yeah,
I don't trust them.
But the judge didn't say anything about that, but it is. That's how it's set up.
No, that's why I'm amazed that both Bradel and Yannetti seem to be okay with letting that happen.
I think they're okay as long as the order is complied with.
Of course. But how do you trust them? How do you trust these guys?
Well, now
to get where we are right now, how do you trust them going forward?
I think they know right now that this judge ain't taking any shit. Excuse me, that's a legal term.
Well,
right?
What would happen is, let's assume that they turn over something that clearly violates the order, okay? And Brennan then, of course, he wants to use it. At that point, you're going to have a chance to squash it anyway, right? Unless it's brought up during the course of trial as a big ambush, they will have other opportunities to step on it. I just feel, why put that on their plate? They shouldn't have to deal with that. If somebody is an intermediary that truly can look at the communications and make the proper determination and not leave it to the fox who's in the hen house.
Right. And we don't know, before, it says, well, the thumb drive was impounded, right?
Sealed and impounded both.
But it came from an extraction of a phone. So we don't know quite frankly, I don't trust anybody to not have looked at that phone and that extraction. I don't trust anyone to not have done it.
I don't either. No.
And then when you get to the thumb drive, which was the whole thumb drive the phone, or was it just supposed to be communications, right? And who made the determination of what goes on the thumb drive? We've heard about these thumb drives, right? Yeah. And then they seem to do drag and drop. So is there Is there data? Is there metadata on the thumb drive of what they're going to turn over? But we did hear something I thought was really important. And when Cosgrove filed a motion in the prosecution case against Aidan Kearney, and he put some conversations Kearney may have had with Karen Read and Yannetti and Jackson, he cherry picked what he put to make it seem like something was done wrong instead of having apparently there were discussions with Yannetti and Jackson saying, look, you cannot do this, you cannot do that, you cannot do that. They made it try to appear that there's some bad collusion, right, to intimidate witnesses and again taint the defense team and take Karen Read. I think this was a huge day, Michael.
And I think, one thing that we kind of skip over because we're going down the rabbit hole of the procedural is substantively, I don't think there's probably anything in this material that matters at all. We know it's a fishing expedition, but I think they're coming up without anything on the hook. Can I use that analogy?
Yeah, no, because the judge was very interesting. He said to Bradel, he said, look, there's supposed to be an order right now that just get this, but what you're asking for on the motion for protective order, which I'll take under advisement, is there's already a belt. Now, what you're asking for is suspenders. In other words, made it very clear that nothing gets shared, given the history, the procedural history of what's happened here, and the 3 docket numbers and how the prosecutors are using the 3 separate docket numbers: the prosecution of Aidan Kearney, the issue of the extraction on the 117, the Rule 17 motion, and the prosecution of Karen Read. And they're all getting muddled into one thing. And so what they want is yes, they want a protective order to make sure that there's a belt of the suspenders. I think the judge is going to give it to them.
Yeah, I think so too. And I think that's as good as it gets under the circumstances, although I'd still like to see a third party that is the person looking at what's coming from one side to the other, not from prosecutor A to prosecutor B.
Yeah.
I don't like that at all. But I think, if we believe Aidan, and he's kind of been involved, he's told us that there's nothing on there anyway that is incriminating. Remember when they took his phone, we went through this, October 6, 2023, and he said most of the activity, took place after that. So what's on there?
We should actually clip that portion of the interview we did with Aidan, who was gracious enough to do it Wednesday night from his car, actually, because that was just before they filed all this emergent application stuff, where he says that and put that out there because that's what he said. And apparently that's not what the prosecutors, the independent prosecutor Cosgrove, that's not what he really wanted. He thought his job was to find stuff, in my opinion, for Hank Brennan, the special prosecutor. He thought that he could find stuff under under 117, but then use it for the prosecution, give it to Hank Brennan. I mean, to me, no issue. I mean, if I were the judge, I would have removed. I don't know how he got appointed this, but as special prosecutor, but I would have asked that the whoever appointed him remove him at this point.
Yeah, well, is probably Morrissey, and his name raised its ugly head today.
But let's face it. I mean, we talked about in other cases, like in the Fonnie Read case, right? That there has to be independence here. And if Morrissey's not going to, after what he just heard, remove Cosgrove, I think Cosgrove did Hank Brennan's team a lot of damage. And finally, we had a judge that seemed to be fair, Michael.
Seems like it, as fair as he can be under this is a weird circumstance. Let's face it. The whole thing is bizarro when you have parallel cases, one that seemingly came out of nowhere, but tries to impact the primary case. I mean, the whole Aidan Kearney extravaganza is only there to help attack Karen Read. That's it. That's the only reason it's there. And now they're using it to try and get information that they believe will negatively impact her case.
Okay, so Dizzy has on, and we're going to keep talking about this. We will get to the new ARCA motion, I promise. So I'm going to have to let you look at that. And why don't I start answering some starred questions?
Oh, is there a new motion filed? It's been filed this morning.
Yeah. In the meantime, let me start answering. Tara Ellis question: is a court clerk the same as a law clerk? You're talking in the court, not in our situation where you can buy to be a law clerk. A law clerk and I was a law clerk. I was a law clerk when I came out to the head appellate judge in the state of New Jersey. It's something you do after law school generally, and then you go on to your private practice, or if you were a law clerk for a head judge, you could actually then go to seek to be a law clerk for maybe the U.S. Supreme Court or whatever. But a law clerk and a court clerk are different. Court clerks get paid in Massachusetts to run the docket, the paperwork, and all. Interestingly enough, the court clerk that we had in the Hernandez case ended up being involved in that whole lab issue about whether or not documents and results were being phonied, and she ended up in some serious trouble. But her job is to actually run things. It's more of a business side, and it's an appointed side. You don't have to be a lawyer, but many are lawyers who do that. So a law clerk will do the research for a judge, maybe even draft opinions for judges, and is usually just out of law school. A court clerk is somebody who is hired as actually part of the system and gets it's a real job, should we say. All right, I hope that answers your question, Tara Ellis. Okay, I didn't put the question up. I should have. Okay. All right. Next question. Joanne, and again, this is one of my favorite handles. Joanne M. Jedi Platypus. Can Hank be sanctioned in some way due to continually misrepresenting the actual facts? Well, the judge gave him outs today because he had to say 3 times, 3 different occasions, he misunderstood. So I guess a judge could sanction him, but so far they haven't. Would you have sanctioned him this morning, Michael?
Probably not. But, he just keeps. Here's the thing. If this judge were overseeing the main case and had seen all of the Hank Brennanisms unfold, maybe. But for this judge, it's just one thing that he's seen, maybe a couple of different issues within this one thing. But no, since he's only overseeing this very limited issue, I don't think there's enough to sanction. Hey, I've been looking at this document, but to be honest with you, the quality is so bad, I can't really even read it. But it's the Commonwealth motion to compel reciprocal discovery of ACCA witnesses or to exclude their testimony. I mean, it's like, haven't we been here before?
Yeah,
but I can't read it.
While you try to figure out some of it, I'll go down and continue with the questions, see if you can see anything that's clear, or Dizzy can get you something that's clear in the meantime. But we'll talk about it. Madeira Beach Caregiver. Hi, Madeira Beach Caregiver. Nice to have you back in our chat. Are these attorneys former from Atlanta? Seems they possess the same inept incompetence today as the first time we watched any of this trial, well, I don't think they're so inept as they are. The word I would use.
You think devious is what they are?
Yeah, I mean, I'm sure that the defense would say they were colluding if they had to say it in court. I won't say it here, but certainly I don't think Hank Brennan is certainly not an incompetent attorney. Okay, just not. And remember, Cosgrove gave some type of speech to some type of ceremony, induction or inception or whatever for Judge Beverly Cannoni. So they all know each other, right? They know each other. Okay. Mama Bug 107 asked a good question. If it's not only the Reed case, why is this not in front of Judge Cannoni? Well, because this came under the docket number of the Karen Reed 117, which involved just the phones. It involved the Rule 17 motion that involved just the phones, and it was related to the prosecution of Aidan Kearney. So that's why it's not right now in front of Judge Cannoni. It's in front of the judge who made the initial ruling, Judge Sisitsky, and actually he took over from Doolin. Is it Doolin? Who's been on vacation. Very interesting. But I think when they go for a protective order, they're going to have to go for all 3 under all 3 case numbers. So you heard the judge when he first started saying, we're only dealing with case number 117. That's what he said, right?
Yes, that's what he said. And that's the Karen Reed case number. But he's also the one who made the original order, so it only makes sense that he was the one to ask for clarification and shepherd that through. So we're seeing if we can get another copy of I just printed it out here. I'm going to disappear for a minute. I'm going to look at it like a hard copy to see if I can make heads or tails of it, and then I'll pop it.
I'll continue to answer questions. Okay, YSL Kells. This is a really interesting question. I think this is what the judge was sort of getting to. Curious, does a group chat with Karen Reed, David Yannetti, and Dr. Turtleboy waive privilege because a third person is party to the communications? Well, it's interesting because Yannetti said they weren't asserting attorney-client privilege or a joint defense agreement. They weren't asserting it on that. It really was a joint defense agreement. Then the attorney-client privilege would come into play. Because, there's been no accusation. There's been no accusation that the attorneys are guilty of any type of jury of witness intimidation. So you can't go fishing and get everything because it includes other people. And all the Commonwealth said they were interested in was for Karen Read, whether Karen Read and Dr. Turtleboy were somehow engaged in colluding of witness intimidation. And clearly, let me just say, no attorney is going to go out there and say you witness intimidation. If they were discussing, if Kearney and Read were discussing, look, we want to have protests and we want to have marches, and the attorneys are going to say, sure, as long as you comply with court orders, as long as you don't scare people, as long as you get the right permits or whatever. And you heard that there apparently were warnings, but that's what the judge, I think, was getting at initially. He was saying in this day and age of group chats, do you get, is there any type of attorney-client privilege, or was there a joint defense agreement in some way? And Yannetti said, absolutely, there was no joint defense agreement in regard to that. And with regard to the privilege, you were only seeking this for a limited purpose, so you can't use it as a fishing expedition to get that. If you're going to go fishing and you're going to go fishing for, marlins, and that's your permit, you can't then use that permit to fish for a shark, shall we say. I mean, it's just that you're limited in what you were entitled to, because you're not entitled to everything, and there is journalistic privilege that goes along. I mean, Aidan Kearney's a journalist. He has journalistic privilege, and no one discussed that today because he has asserted that in the past. So I think the judge was getting to it, but that's the answer. His order was very clear. It's just between Karen Read and Aidan Kearney. Robert Shank, David Yannetti should have joined in the motion, right? Or it doesn't matter. It doesn't matter whether he actually joined the motion. He has standing because it's under Karen Read's case number. And with regard to the protective order, he really can't join in that, in the sense that it doesn't arise from his client's phone. The person who has standing there for the protective order is Aidan Kearney. And if Aidan Kearney gets the protective order, it benefits everybody. And I think he is going to get a protective order, or the judge is going to say, you don't need the protective order because I've been very clear that you, Commonwealth, don't do this. You, Commonwealth, aren't entitled to share it. Now, if this judge finds out that Mr. Cosgrove or somebody else has shared this information in violation of the court order, then I think this judge, unlike some other judges we've seen in this case, could take some big action here. And if that happened, that would really be a blow up. But we don't have that right now. But that thumb drive, how did it get in the possession and supposedly sealed? Who sealed it? Whose possession has it been in? Actually, what physical person has it been in? Cosgrove? Did it go to the police? What's the chain of custody? Those are questions that all Michael and I wanted to know. But apparently either they know it, the attorneys know it, and they're not. They thought that they had bigger fish to fry today, which is that there had been a violation, clear violation, and a clear underpinning, in my opinion, that there was. And Cosgrove almost said it at the way I actually started. Well, I was operating under my case, but basically, the intimation was that they were sharing information. That's why Hank Brennan had to get up and say, no, I never asked for that. I never asked for that. I only asked for this, because Hank Brennan didn't want to be brought in the same net as Cosgrove, who seems to have thought that his idea was that he could share all this information with Hank Brennan. Okay, so that's where I think. That's why Hank Brennan was really into his turtle shell, I think, at the end. Joanne M. Jedi Platypus again. I don't know why both cases need special prosecutors. Are the regular Commonwealth prosecutors so useless they can't try either case? I think because there was this conflict of what may go on. Obviously, I don't know about why Hank Brennan was brought in as a special prosecutor. Maybe it had to do with the fact that the office of Morrissey was actually the lawyers for the office in the federal investigation, and therefore they felt they needed a special prosecutor. Or, we're not privy to the rumors out there that no one wanted to retry this case, or he felt he needed to have big guns retry this case, someone that could match Alan Jackson and match David Yannetti, and he felt that his prosecutors weren't up to it. Well, if his prosecutors weren't up to it, see, the taxpayers really have to stand up there and say, wait, why are we paying money when we have, how many prosecutors in that office? I've seen it, but I don't remember. And none of them are able to try it. With regard to Aidan Kearney, it had to do with, again, the conflict of interest, because you don't want to, it's supposed to be separate. Not so, since he has a journalistic privilege, the whole issue is supposed to be separate. But in fact, good question that the taxpayers should all be answering. Okay. Why would the judge speak at the end? Because he decided, all right? He had decided. It was kind of like the other day when we heard Judge Kearney stop Robert Alessi in the issue of the attorney-client privilege and said, stop, I don't need to hear anymore. He really had decided. And also, at the very end, they were discussing the issue of the protective order, which was not Yannetti's motion of a protective order. It's Kearney's motion to protect, and Kearney has the standing. Aidan Kearney has the standing, Dr. Turnerboy, to make that. So he didn't need to hear from Yannetti because Bradel when Bradel got up, who represented Kearney, and said, look, we feel we need this. And the judge said, you feel you need suspenders attached to the belt I've already given you? And Bradel said, yes. I mean, that kind of stands and helps everybody. So he made up his mind. The judge, in my opinion, just like I've talked to you about Judge Kearney, sometimes feeling like she thinks that the wool is being pulled over her eyes by the defense. This judge thinks that there was something underhanded going on, in my opinion only, that there was something not quite right, and that he needed to reinforce the fact that the order that he's been giving was followed specifically. And that was specifically only to give the communications between Kearney and Karen Read for a very limited period of time, okay, from a very limited period of time. Again, Hank Brennan, to me, then went on the attack at the end, and the judge just smacked him down. He went on the attack of the defense team, and the judge just smacked him down. He said, we're here for this. We're here for this, okay? So the fact that this was an emergency application by the prosecution, right, turned out not to be so good for them, right? Because that obviously got the judge pissed off, like, well, you're seeking all this now. I told you what you can get, and now what you're seeking. And I think he felt that the wool was being pulled over his eyes. He felt that they were trying to do, in my opinion, something underhanded, and he felt he had to say to them, this is the order. This was only what you get. And that's why Hank Brennan had to keep saying, maybe there was a misunderstanding. Now, the judge gave him that out. Did you misunderstand me? And Hank Brennan said, maybe it was misunderstanding. Maybe there was a misunderstanding. Maybe, and I apologize if there was a misunderstanding. Then what do you mean there's no misunderstanding? The order said one thing, and you were trying to somehow get receipt on an emergent basis from the Commonwealth, from Cosgrove, who's a special prosecutor of Aidan Kearney, more that's on. Isn't this interesting? I have a group Justice Serve TV voicemail phone call. I think I should delete that, okay? Because I'm on with you. Should I ignore this? Should I ignore this group phone call? Who's calling me from our let me check. Michael Bryant, are you back? You back, Michael Bryant? You were calling me, okay?
I was not calling you, no.
Yeah, here's is technology lying?
It was a WhatsApp group thing, so it could have been. It's like a Signal, had a lot of people on there.
Yeah, that's right. Signal.
I don't know who initiated it, but I looked at this doc as best I could, and now I have brain damage. It is rough. All I can tell you is it's more argument about Rule 14, the ACA experts, and I think it was spawned by the production from the defense. They had to send a note, right, saying we are producing this information under Rule 14 as it relates to the ARCA experts. Again, it's like deja vu because feels like we've done this over and over and over again.
filed the Commonwealth. Just I haven't seen it. I should go look for it now. I'll go look on our drive. The Commonwealth filed a motion this morning.
Yes, this is and it came after the defense offered up, and that one is a little more legible. And let me see while we're chatting if I can drag that one up. This one is basically their notice saying, here's what we're producing. This is the stuff we're producing under the reciprocal discovery agreement. And so they did, and that came out. That was at looks like about 8:40 this morning. And then that precipitated the response by the prosecution, which was basically saying that's BS. What they say they've got is not properly providing us what we need under Rule 14, blah, blah, blah.
Okay, so
again,
why don't we go through what the defense produced? That's the notice of the reciprocal.
Okay, that's what I'm opening up here. Stand by.
I know we don't usually go through line by line, but
Stand by. Let me, because I've never seen it until just now. So let me.
I have it up on my screen. I just pulled it off our drive. I don't know.
Yeah, that's what I've got. I just had a couple more steps to get it.
Okay,
up for us.
Bear with us, everybody.
Okay, so there's the notice of reciprocal discovery. Woo! It's twisting and turning. There we go. Okay, so here's the stuff.
Okay.
There they are. Witnesses
submits the following notice of and reciprocal discovery means you're engaging in discovery under the court rules.
Diz said she accidentally pushed the phone button. That's what that was about.
I've been like, who's calling me? At least I'm loved. At least I'm loved by a member of our team who tried to. A butt dial in a case that has 2 butt dials.
Yeah. Well, I did not butt answer it.
I always thought, well, maybe I should answer. Maybe it's Michael Bryant calling me, and he wants everybody to hear. Unlike just kind of like what Cosgrove was doing in that case. Oh, everybody, why don't you just hear everything that we've got? Okay, so this is regarding the ARCA witnesses, Dr. Daniel Wolf. Remember, there's 2 Wolfs in this case. There's 2 Dr. Wolfs. This is Dr. Wolf with an E, and Dr. Andrew Rensler, right?
Yep.
Okay, I'll read request number 1 while you continue looking at the document. A complete statement of all opinions to be expressed by Daniel Wolf and Andrew Rensler and the basis for each opinion. The answer is this information is in the possession, custody, and control of the defense has already been produced and can be found in the ARCA report, voir dire testimony, and trial testimony of Dr. Wolf and Rensler. So they're saying you have everything.
Yeah. It's like, all right, already. We've already given you everything.
Right. And not only that, they testified in trial. So, okay. Request number 2 from so what it is the request is from the Commonwealth, and then this is the answer from the defense. The request from the Commonwealth is all notes, reports, materials relied upon either, and there's a seek after that, either witness for reviewing this specific case, request seek, for materials is not limited to expert's report. The Commonwealth is requesting all materials relied upon in review, even if the materials are not part of the expert's report or opinion at trial. And then the defense answers this and says, all materials reviewed by Dr. Wolf and Dr. Rensler were listed in ARCA's report. The United States Attorney's Office formally authorized the defense to independently retain. Oh, this is interesting. This is really interesting. I'm sorry, I just stopped here. The United States Attorney's Office formally authorized the defense to independently retain ARCA and produce additional discovery to the experts for their review on March 26, 2025. That same day, the defense provided additional materials to ARCA, including Welcher's report for potential rebuttal this testimony. All materials were immediately produced to the Commonwealth in reciprocal discovery. So this is the first time we're hearing that the U.S. Attorney's Office had a formal authorization to the defense to independently retain ARCA. Okay, that is really interesting. That's so
the way it's written, the date makes it a little confusing because it says the authorization to retain ARCA and produce additional discovery for the experts for their review on March 26th. Well, it wasn't for their review on March 26th. That's when the authorization took place, right?
Right. That's when
either way, that's 2 days ago.
Yeah, but isn't that? But apparently, in order to what we're seeing here, and in order to stop the prosecution from saying, well, you just hired these people. You had apparently you got additional authorization, and I don't know what additional discovery may have been produced, but you had to get some additional authorization for the defense to hire them from the U.S. Attorney's Office. Do they become?
Well, now I know what the prosecution is upset about and what they're bringing their Rule 5 motion about. This happened 2 days ago. So under Rule 14, it's late at the very best. And so they're asking basically to exclude anything that relates to this most recent revelation. And I guess it's specifically Dr. Let's see, which one it's the Welcher rebuttal testimony, I guess.
Yeah, but that if indeed the U.S. Attorney's Office's request was out there, they just acted upon it 2 days ago. That's something.
That's the issue.
The U.S. Attorney's Office takes their time. The defense has no control over what the U.S. Attorney's Office does. Neither does the prosecutor.
That's definitely going to be the issue. If I could read it, I would tell you for sure, but that's my guess.
Okay. Now, request 3 from the prosecution was a copy of all materials provided to ARCA LLC, Daniel Wolf, Andrew Rensler, or any representative of the United States Attorney's Office by any member of the defense team or by the United States Attorney's Office. The request includes all materials, including written, documentary, video, witness statements, and witnesses produced. So here's their answer. All materials provided to ARCA by the defense have been produced in reciprocal discovery. A copy of the grand jury subpoena issued by the United States Attorney's Office to Attorney David Yannetti, dated November 22nd, 2022, demanding production of, quote, all materials produced in discovery to date by the Commonwealth versus Karen Read, case number 2282CR0117. That's the case we just heard the other discussion on, as well as all relevant investigative material was produced to the Commonwealth in reciprocal discovery. Pursuant to that subpoena, the defense produced the discovery included in Notice of Discovery 1-47 to the United States Attorney's Office. On October 22nd, 2024, the defense provided to the United States Attorney's Office with discovery relating to the vehicle reconstruction for the Department of Justice's determination regarding whether to provide this information to provide this information to the ARCA experts. The defense understanding is that this information was not provided to ARCA, Dr. Wolf, or Dr. Ressler by the United States Attorney's Office based on and then there's a footnote. A copy of the specific information produced to the U.S. Attorney's Office on October 22nd, 2024, relating to the reconstruction was produced to the Commonwealth in reciprocal discovery. And then you go back to the document. Based on our best efforts, that's the defense's best efforts, all reasonable review of all files, all additional information relevant to this request was produced to the United States Attorney's Office by the defense. It was provided to the Commonwealth in the federal materials both sides received from the federal government pursuant to our mutual TUI requests in February 2024. The defense understanding is that the only discovery materials produced to ARCA by the U.S. Attorney's Office were the materials listed in ARCA's report. Anything to be upset with there?
No, except the prosecution's just not going to believe that. They're going to believe that there's more that hasn't been turned over. That's what they're claiming.
Well, then they're going to have to go to the U.S. Attorney's Office, aren't they? So request 4 by the prosecutors were all materials provided to either witness after the conclusion of the defendant's first trial. And the answer by the defense is all materials provided to Dr. Welf and Dr. Rensler after the conclusion of the defendant's trial have been produced. Now, what are those materials?
Oh, I'm sorry. I'm digging up the document, which has been cleaned up now. Thanks, Diz.
Okay.
I will try.
Yeah, well, you're looking at request 4 is that the prosecution wants all materials provided after the first trial. And the defense said they provided all materials that they sent to Dr. Wolf, Domino, after Dr. Wolf and Dr. Rensler, after the conclusion of the defendant's trial were produced. So we want to know what those are too. I mean, because they're saying defense is saying they produced documents to them afterwards, after the trial. Request 5 by the prosecution was describe and produce any exhibits to be used as summary of or support for the opinion. Defense says all exhibits, excluding the exhibits necessary for rebuttal of testimony, have been produced. Okay, and that's appropriate. You don't need to. Until Walter testifies, you You shouldn't have to produce your exhibits that you want to use, so that the prosecution can use your chalk to try to not fall down the rabbit hole. Request 6, describe all compensation paid to either expert for all work done regarding this case, including case preparation, testimony, travel, and expenses. The defense answers, the only funds paid to ARCA to date is $27,606.41, detailed on the invoice previously produced to the Commonwealth in reciprocal discovery.
So a little higher than it was before. Okay.
I think it was 24,000.
It was. Mm-hmm.
27, right? So we don't have the detailed invoice. So, but the Commonwealth does. On March 26, 2025, defense retained ARCA on March 26.
Yes, this is 2 days ago.
Okay, for the second trial. A copy of that retainer agreement and rate sheet was produced to the Commonwealth. So they're saying that they just retained them for the second trial, and they've also obviously also retained them, it seems, to give a rebuttal or give their opinion a rebuttal to Wechsler, right? That's what it seems, right?
Yeah.
All right. And that's probably the additional documents that were sent, in my opinion, to ARCA, because they have to see what the Commonwealth was using and then send it to ARCA, because now that they're retained ARCA, they're retaining them not only to what the federal government retained them for, but additionally to rebut what the Commonwealth is
right. And now, from that moment of retention, it's a more traditional expert-attorney relationship. And so they would be giving them whatever material might be important for them when they testify, either on direct or as a rebuttal witness.
Yeah. Request 7 from the prosecution, provide any contracts, agreements, or documents relative to Daniel Wolf, Andrew Rensler, and ARCA LLC discussing compensation relative to this case. The defense then answers, all information responsive to this request has been produced. Then request 9, seek, and that's because it should have been number 8. It's misnumbered.
Tells you how quickly they're jamming this stuff out.
Yeah, it's misnumbered. And that's what happens when sometimes you take out a request and then you forget to renumber afterwards. I mean, we've all been there as lawyers, right? You see it in interrogatories and
now there's some better software that actually will fix that for you.
Will fix it, right?
And collapse the numbers. Yeah.
But apparently that wasn't done here. So request 9, seek. Let me just jam it to you because it's wrong. It should have been 8. Provide all written communications, including emails and text messages between any member of the defense team and employees of ARCA LLC. And then it says all information responsive to this request has been produced. Because let me tell you that once you have that attorney expert relationship, you can have texts and emails with your somebody if it's relative to draft reports, and those get protected under work product privilege. So they're gonna fight over this. That's a fight.
Of course, they're going to suggest that those are reports prepared in anticipation of testimony, and therefore they're discoverable because it's an opinion or something that you are supposed to provide when you have an expert that's going to be testifying on your client's behalf.
Okay. By the way, Michael, just before I get to request that, did you realize that when we said we're going to go quickly into this is going to be a quick hearing on Aidan Kearney, that this was going to happen right in the middle of the Aidan Kearney hearing, and that we get this thing that's been fought over, and where Hank Brennan has accused defense of hiding things, and we get this discovery right now and all this information. Who knew? Only in Kearney. But request 10, provide copies of all testing, not previously disclosed, including crash tests, video reenactments, and any other testing materials and results, regardless of whether the witness will testify to the information at trial. Now, it's answered by all information in possession, custody, and control defense has been produced. To the extent additional testing is conducted in furtherance of rebutting the testing conducted by Aperture LLC, that information will be produced forthwith. In other words, the prosecution has produced witnesses that they're going to say counter ARCA. Defense is now also getting other backup testing that they say will support the ARCA witnesses. That's how I read it.
Yep, and this Aperture LLC, I've not seen anything from them, although it sounds so familiar. Maybe I'm just not. Maybe I'm misremembering it. Maybe I've got a brain.
Dizzy will tell us right away, right? I'm sure on that. I've seen the name. Okay, and it may be related to one of the witnesses that they're employed by. Request 11, provide all written communications, including emails and text messages between the United States Attorney's Office employees of ARCA. The defense says all information in the possession, custody, and control of the defense has been produced. Okay. No.
Yeah. And then that could include anything that predated the defense connection with the ARCA people, because the feds are the ones who brought them in. So the feds, their file, whatever it may include, could have all of that stuff in it or not, but the defense only has to give what they've been given.
Right.
They don't have to go looking for something that predated their connection with the ARCA people.
Yeah, and that's why I want to go, when we finish this, I want to go back to the one thing about testing, because the prosecution asked for testing that was given to the U.S. Attorney's Office, and apparently implicit in there is there may have been some testing on the taillight or a car that wasn't given, that the defense must have done.
Or it could have been, if you think about the ultimate ARCA opinions, that the car did not contact John O'Keefe. Did they run some with some dummies, with any of those normal tests?
Well, and the defense could have done even with other experts beforehand and not provided it, but that would be privileged, because you're allowed to have experts that help you and that are never identified as being experts in a case. Request 12, to provide all communications between the U.S. Attorney's Office and any member of the defense team as it pertains to the expert testimony in this case, including dates and substance of phone calls, copies of any written correspondence, dates of any strategy meetings. Oh, yeah, I'm sure with the U.S. Attorney's Office, there'd be strategy. Yeah, that's my comment. And list of materials received from the U.S. Attorney's Office. In case they don't know, the U.S. Attorney's Office doesn't do strategy meetings with defense teams, okay? Just so you know, all right? They're lucky they got a TUI request response. And then the answer is all communications responsive to this request have been produced. Here you go. The TUI materials received by the defense from the U.S. Attorney's Office in February 2024 are identical to the TUI materials produced by the Commonwealth. And that's the request by both teams. They had a joint request to the U.S. Attorney's Office because of a case named TUI to get documents in the possession of the U.S. Attorney's Office.
And that's been represented at least once in prior hearings, that we all got everything from the U.S. Attorney's Office.
Yeah. At the same time, as a matter of fact, Hank Brennan got a call from the U.S. Attorney's Office that the investigation has closed before the defense got any notification. I don't believe they got the notification. They got their notification from Hank Brennan, if I recall, that said that the case had been closed at the U.S. Attorney, whatever case it was. Request 13. I have the request, but I don't have the.
I don't either. So it's a mystery.
So provide a copy of all written requests that have been made by the defense team pursuant to 28 CFR 21. That's the Code of Federal Regulations, by the way. It used to be in white books, and you always had to go to the Code of Federal Regulations just to tell you how to do something. And every I don't know, the departments has different codes. Excuse me, I'm gonna have you take over while I drink something, Michael.
Yeah, so we have no answer to this. Whatever the response is, it's in there somewhere, but we just don't have it in the document that was filed or has been made available. A copy of all written requests that have been made by the defense team pursuant to the code relative to either expert or ACA as an entity. So
now I know how singers feel when they need to have grapes after they have.
Is that what it is? Is that the deal? So yeah, so I don't. This one just looks like a catch-all. Like in case we miss something above, we're throwing this one in just to see that we've got everything we could possibly get. So no doubt, this response is what precipitated the. I'm going to go to this. Let me give you a programming heads up. I've got about 10 minutes, and I've got to jam out of here.
Are you sorry? Before you do that, there's a question on what we just said. I'm sorry. I can't read it because I don't have Tara Ellis, right? I don't have my regular glasses, and I thought, Bev.
Which one are you trying to read now?
The one that's from Tara Ellis. I may have to have you read it. I thought Canoni had already approved them. Is this new motion something she can change her mind on and now allow?
Oh, you read the question. I'm now with you. Okay.
Before you went to the answer by the motion by the government. Yeah, she could change her mind. Remember, she said she wanted a hearing before they testified. She could change her mind.
Oh yeah. Yep. Living, breathing thing. Okay, so let me find the latest.
I'll let you take over reading.
Which I have pulled up. I believe this is the right one. I'm pretty sure. Let me see if I can drag it over and make it the right size for us. Get a little size on there. Okay. Maybe too much. Back it off a touch. There we go. Okay, so, oh no, this is the notice. I'm sorry. My apologies. Let me find again the one that we had to have.
As we are on the air talking about the this whole other issue, and then we end up with this.
Yeah, I want to make sure I find the right one.
I should have let everybody know on X that we were discussing these motions right now.
Okay, I'm gonna have to go fishing for it again. I downloaded it, but I think I've lost it. Hold on, stand by.
Okay.
There it is. Hold on. Again, this is filed just really as a result of. No, this is not the right one. I'm sorry, this is not the right one. This is the notice of reciprocal discovery. That is not new. That is not the new one. So I still don't have a good copy of the
Do you have one
by the prosecution?
I know you had one that it was very hard to read, but
yeah, I did, and I thought we got a new version of it. And it's marked new in our file, but it's not the right one. It's the same. It's the notice of reciprocal discovery.
Is there a date? Can you read as to when the
Let's see.
Discovery? Because now they've been putting filing times on March 28th at 8:40.
Yeah, that's when their notice of reciprocal discovery was filed. The question then was, okay, when was the following motion under Rule 14 to exclude ARCA or to have another hearing on their testimony? That was the request by the prosecution, and I just can't read it. It's all I could read was the caption.
Yeah. So they're probably going to say, what? If you had to take a guess in the 10 minutes we have before you have to leave.
Okay, hold on here. It looks like, and this is a cleaner version. It looks like 840 something.
So right
almost like they got it, and then they immediately, they got the notice of reciprocal discovery, and then immediately fired off a motion to compel. So if it's very possible, and I can't read the time on it well enough, it's very possible this motion to compel was immediately followed by the motion or by the notice of reciprocal discovery. I can't read the minutes.
Then they had to sound like they had it ready to go. They didn't care what was produced, right? They didn't give a.
Yeah, and I can't read the minutes. They both have an 8 o'clock hour on them.
Yeah, one's 8:40. Look, I thought it was 8:48 for the defense.
Yeah,
so
it looks like a 4 on this motion to compel, but that's about best I
Yeah,
got.
but that tells me that's not that they didn't even read, read what was said. They didn't even read what was said. They're just assuming that there's more out there that they want, right? And that's what they're assuming. There's more out there that they want, and they're gonna get it. By the way, thank you, Blessed Mom from Texas, for a member for 2 months. You love this channel. Thank you for being real, folks. We call it as we see it. We call it as we see it. And thank you.
I'm going to try one more time to get this document up, even if I have to go. You might be able to wander.
Well, if not, I know we have Doug Weinstein on at 5 o'clock tonight. We want to talk a little bit about this document with Doug Weinstein, because what I'm seeing here is they want, they're going to want what the defense is going to produce in rebuttal to the Commonwealth's case. That's what they're going to look for, right? And I don't think they're entitled to that. I don't.
So here's the guts of this. They're looking for a viable remedy for the defendant's repeated Rule 14 violations. That's and so let me just go through it here real quickly.
What do they say is a Rule 14 violation? They've got all the documents.
Well, that's just it. That's the argument, that they're saying they're complying, they being the defense. Prosecution says they're not complying, which is that's a very typical discovery type argument. So right. the court's got to drill down and decide whether or not
they're going to fight over. They're going to fight over the fact that the formal retention agreement was just what.
That's why I pointed that out. It was 2 days ago that they formally retained the ACA experts. So that's going to be. I'm reading here as we go. 5-time. Okay, so at sub 3, you'll see defendant's position, the material ordered in Exhibit A, which we don't have, are not within the custody and control, therefore cannot be provided, is inadequate. The defense must comply with the court's order for the defense to call the ARCA experts as witnesses.
What did they had a hearing. They testified at trial. What else do they want?
Okay, so here we have from March 20th. Additionally, it was disclosed to the Commonwealth for the first time and in open court that Yannetti had received federal subpoenas from the U.S. Attorney's Office to produce his entire case file. We talked about this when it happened. On the 25th, 3 days ago, the defense further disclosed for the first time that the subpoena Yannetti was referring to was an ongoing federal subpoena, ongoing in quotes. On the 25th, the Commonwealth was informed the discovery produced to the defense was in turn being provided to the United States Attorney's Office in an ongoing manner, and I think that's probably supposed to be matter, and included the entirety of the Commonwealth's discovery referenced in Notice of Discovery number 1 through 57.
Now I go back to the request number 3 because I think here's where they're going to be kind of argument. In the request number 3, that's where we have the grand jury, the order to Yannetti, right? This United States Attorney's Office grand jury subpoena to Yannetti for his file. And there's the line that says, pursuant to the subpoena, the defense produced discovery, included notice of discovery 1 to 47, whatever that was. October 22nd, 2024, the defense provided the United States Attorney's Office with discovery relating to the vehicle reconstruction for the Department of Justice's determination regarding whether to provide this information to turn over to the ARCA experts. The defense's understanding is this information was not provided to the ARCA experts. So it sounds like there may have been some vehicle reconstruction by the defense or some kind of reports or some consult that they gave to the U.S. Attorney's Office that the ARCA experts did not use, and that's what there's going to be a fight about, right?
That's definitely part of it. There's also here at 6 the source of all information about DNA and forensic evidence that you provided to Dr. Wolf and Dr. Rensler prior to their trial testimony. I'm not sure if they think there's something they weren't given then or not.
Yeah. So I mean, obviously, we're going to have a hearing on this now. Jury selection starts Monday. Today is Friday. Is she going to call them all in on an emergent basis, or she's going to do this?
Well, Monday's a free day, right?
Monday's a free day, so she's going to call. She may call them in Monday. Although, you know, if Alan Jackson went back to California, I don't know if he did.
I can't believe he'd be back there on the eve of jury trial, right? I mean, the jury selection on Tuesday. He's going to be in the area.
Yeah, I agree. It looks like from
I would say this weekend he's moving here. If you know what I mean.
Well, I think they have already. When you see them, they had a video of the three of them cooking in the kitchen. Yannetti.
Oh yeah.
You know, so obviously, what many defense teams do instead of renting houses, renting, you know, staying in hotels.
It's Airbnb.
Yeah, Airbnb. They rent a house, right?
Okay, I got to get out of here. We'll get into this more tonight, right? If you want me to leave this up and I'll just duck out, or what do you want?
No, let's say goodbye to everybody. Unless somebody has, we'll try to. What I would like you all to do is, if you have a question, could you put it in? This is gonna be on. We'll take a look at the comments afterwards, and then we'll try to use those comments when we have Doug Weinstein. Now, Dizzy, do you need to portal this into Doug Weinstein's hearing? Do we need to stay on so you can portal? I don't know the answer. Michael can go.
I think we're fine. I think, yeah. There's going to be one for tonight at 5 o'clock.
No, right? Already done. She's the most amazing in the world. All right, so put them in the comments. I will take a look at the comments to this, okay? And we'll try to address them with Doug Weinstein when we talk with him tonight. 5 o'clock, and then at 6 o'clock tonight, we are going to be on Will the Galera's show. We're going to, you know, change at like 6:55, and then we're going to move to his show at 5:55. And move to his show at 6 o'clock. So we'll have plenty of time to talk about this later. Thank you all for coming.
And we'll see you later. Do the right thing. Whew.